Hi, my name's Isaac Shutt. I'm an estate planning attorney. I'm licensed to practice law both in Texas and in Wyoming. Today I'm going to tell you how not to name minor beneficiaries. So here's the thing. We have a lot of clients who are interested in giving away an inheritance to either their children or their grandchildren or just other young beneficiaries. And it's amazing to me that almost all the people who come in and talk with us about giving property away to young people have the wrong idea in mind about how to do that. And so I'm going to do away with some of those common misconceptions in this video. So the first thing I would say is you need to pay really careful attention to your beneficiary designations aside from your will or your trust. So what I mean is if you have like an IRA or whatever brokerage account, investment account, savings, whatever, be careful about putting a minor as a direct beneficiary on those accounts. Because here's the thing, if you pass away and you've listed a minor beneficiary on those accounts, it's probably illegal for that minor beneficiary to directly get that money. So where does that leave you then? Well, in Texas, we would say the court can be, you can file a request, somebody can file a request to create a guardianship of the estate for that minor beneficiary. But there's two huge problems with that. Number one is that's a big, long court experience that's going to cost thousands of dollars and require a lot of time and attorney hassle and all of that. But number two, the judge may not even grant the guardianship of the estate. So the way that scenario plays out is minor is listed as a beneficiary. Let's say there's $100,000 in the account. The minor can't get it because we're dealing with a minor. And so that insurance company or whatever says, oh, no problem, go create a guardianship of the estate for that minor. And so some well-meaning relative goes and hires an attorney and files for guardianship of the estate, spends $5,000 plus, only to find out that the judge isn't even willing to appoint a guardian of the estate. So the moral of that story is on your beneficiary designations, don't list a minor. So let's just do away with that one. Now, when I tell people that, they say, okay, well then what I want to do is instead of giving the money, to the minor as a direct beneficiary, I'll list, my brother or some other older relative as the beneficiary, and I trust that person to give the money to the minor after I pass away. Don't do that. Just don't do that. There's two glaring problems with doing that. Number one, I don't care how much and how emphatic your brother tells you that if he's listed as the beneficiary, he will for sure give all the money to your minor daughter. Once your brother is the beneficiary, it's his money. He can do what he wants. And it doesn't matter what you and he discussed years before. None of that's going to be provable in any courtroom. And so basically he's got this $100,000 to his name. Whether or not he chooses to honor what the two of you discussed, who knows? But you're just trusting him to do that. And I wouldn't do that if you're dealing with a lot of money. People are crazy when you're dealing with large sums of money. Number two, even if in that scenario your brother was willing to do the honorable thing and use the money for your daughter, guess what? There's all kinds of problems with that legally. So he also can't legally give money to a minor. So the government would treat it as he's inherited it through the beneficiary designation, and now he needs to give it to the young kid, but he can't because there are laws against transferring too much assets to minors. And even if he could do that, then you have the problem of it would be considered a taxable gift from your brother to your daughter, because the government would say, well, it was now your brother's money legally, and if he chooses to give the money to your daughter, that's a gift from him. So don't do that either. Don't list some other relative with the hope and the prayer that if they're listed as the beneficiary, they will give the money to the minor beneficiary the way you would want it. Just don't do that. Okay, so those are the wrong ways to do it. I'm not going to leave you high and dry though. Let's talk about what you should do, because there are some really easy ways out here. Okay, so one thing is, a lot of our clients will have a last will and testament, and if you have a last will and testament done by an attorney, that's typically going to have some special language in there dealing with, what if there's a minor beneficiary. So typically that's going to be something called a contingent testamentary trust. And that contingent testamentary trust is basically a little basic trust that would go into existence after you pass away for the benefit of those minors. And you can actually list that trust as the beneficiary on all of your beneficiary designations. So instead of listing your minor daughter as the direct beneficiary on your life insurance or whatever, instead you could list the trustee of the trust of your will. And so that's a good basic way to do it. Now, obviously you have to have a will first, so you should probably see a lawyer to make sure that your will is up to snuff and has the right sort of contingent testamentary trust language in there. And then the other main option for doing this kind of thing is actually to have a standalone trust, or a trust document that you've created with the help of an estate planning attorney. And this is where you really can take things to the next level in giving money to a minor. Because a lot of times when we have clients who want to give money to a minor, they don't want there to be like a massive lump sum going to that minor at a particular age, because even though it might be legal to turn over assets to an 18-year-old, and you could have your trust listed as the beneficiary, and then that trust could say, okay, when the kid's no longer a minor, the trust dissolves and it goes to the minor directly. Why would you give an 18-year-old that much money? I like to think I was pretty responsible when I was 18 years old. Let me tell you something. As a 25-year-old, I would have dealt with it totally differently. I think as an 18-year-old, I probably would have gone backpacking in Europe or something and blown a ton of money doing that kind of thing, thinking that was a very responsible thing to do. And as a 25-year-old, I probably would not have done the same thing. So if you go this route where you set up a trust with an attorney and then list the beneficiary designation as that trust, now you can customize how that young beneficiary will get her or his share. So basically you could have it paid out like so much per month, or paying for education, or so much per year, or really the sky's the limit. We do all kinds of really creative things when we do trust distributions, because it can be totally custom to you and whatever you want. So when you do it this way, basically you're getting a beneficiary designation on steroids. So it's really the best way to go. So if you do it the right way, instead of listing a minor beneficiary, you're going to either list your contingent trust in your will, or you're going to have a real standalone trust that's totally customized to your preferences, and those distributions are special to whatever you prefer, and that's really the best way to go. One other thing I'll mention just before we conclude this video, I want to mention that if you don't do this right and you list a minor beneficiary and the judge turns down the guardianship of the estate and all of that kind of stuff, you might be wondering, well, then what would happen then if I've got minor beneficiaries listed on those accounts? Well, a lot of times what happens is that the money stays with that company until the kid is 18, and then they'll turn over the money then. So if you've got $50,000 or $100,000 or $1 million with life insurance or an investment account or something like that, and you listed a minor and then you croak, well, guess what? If there's no guardianship of the estate, typically what's going to happen is that life insurance company is probably just going to hang on to the money, or the bank's just going to hang on to the money until that kiddo reaches age 18. And then even that isn't so great because now we're turning over the keys to a ton of money to an 18-year-old with all the wisdom that they have. So typically not a really great idea. So don't do that. Be really thoughtful about your beneficiary designations on all of your accounts, especially when you're dealing with a minor. Go consult with an attorney to make sure it's done right, because if something happens to you, it really could be pretty disastrous. So I hope you found this video helpful. Again, my name is Isaac Shutt. I'm an estate planning attorney licensed both in Texas and in Wyoming.